Well, thank you so much for giving me the opportunity to talk to you today. I'm sorry that I'm not able to be there in Copenhagen, but unfortunately I've had this urgent client regulatory matter which has kept me away from you. I have had the advantage though of reading Paul's presentation just before mine, and I have to say that I agree from a European point of view with almost everything that he's said about the regulatory environment. What I'm going to do here is talk to you about some of the straightforward social media type issues that we've had that will affect those of us in the medical profession as well as people more broadly. And I'm going to try and highlight some of the risks to you. Some of you will know that there is a set of slides. I hope you've been able to see that. If not, you can download those slides from my LinkedIn profile. I'll say next slide each time for those of you who are using slides, but if you're not using slides, that doesn't matter. I hope that there's enough of interest here anyway. You can download the slides afterwards. So without further ado, if we look at the first slide, I think it's important that we look back at where we were just 8 years or so ago with social media. I like this quote from Thomas Friedman, who says in 2005, Facebook didn't exist for most people. Twitter was still a sound. The cloud was something in the sky. 3G was a parking space. Applications were what you sent to colleges. And Skype was a typo. And it's interesting how far we've come in such a short space of time. For example, as you know, the slides for today's presentation are on LinkedIn. I'm speaking to you over YouTube. We've told people about the event over Twitter, and I'm hoping to join you later on if I can to answer questions over Skype. So social media pervades our lives, and of course patients and clinicians expect pharmaceutical companies, for example, or hospitals to engage with them over social media as well. Now, the critical difference, I think, between the regulatory environment that Paul described to you and that in Europe is that we've got a real concentration on data security issues. It's important to remember that personal data has a value. That's the same the world over. But there have been different political reactions, particularly when government has lost health data, and that's happened in most of the civilized Western world. There have been different political reactions, and the legal system in different countries has reacted differently. We've had different enforcement regimes even within Europe, and obviously the contrasting approach between Europe and the US. Europe having all-encompassing data protection legislation, and the US still having that relatively narrow focus on some sectors, health included. If we look at the next slide, which is a map of Europe, if I was giving this presentation to you even 3 or 4 years ago, I would have said that there was a real difference between the attitude to personal data from the east of Europe versus the west, from the north against the south. I think there's more of a convergence in terms of attitudes. Yes, some countries like Hungary do have specific provisions that affect the use of health data because they're wary of the past regimes and how health data was used then. But I think there's more of a coming together across Europe, and we certainly see, for example, in the UK, the data regulators' concentration on health cases shows that this is a real concern to us in the west of Europe too. So next slide, what sort of issues have we had already? Well, already we've had issues about the overuse of confidential data in social media. One of the earliest cases on the next slide goes back some years, the Bodo Lindqvist case. Here a church worker set up a site for those preparing for confirmation. It was meant to make that whole process more accessible, if you like, at that very important stage in the celebrant's church life. The little site she set up said that one parishioner had injured her foot and was working half-time on medical grounds. She was fined as a result by Mrs. Lindqvist by the Swedish District Court, who fined her the equivalent of about 400 euros, and that fine was upheld by the European Court of Justice in 2003. We've had another example in a non-medical environment, but it illustrates the same point in the UK, the case of Robbie Hastie. Robbie Hastie was a bank worker. He worked for Bank of Scotland, and he revealed on a social media site details of some football players that played for his favourite club. He pleaded guilty to a data protection offence of knowingly or recklessly disclosing information without consent. He was fined roughly the same as Mrs. Linkfist, £400, and the Bank of Scotland, his employer, cooperated with bringing him along to the court. On the next slide, we've also had issues about with the overuse of social media or freeware in patient care. So if you click over a slide, an example of that would be the Burnett practice in Armagh, a relatively recent case. This was a doctor's practice that tried to get with the times, I think, partly for cost reasons, and we're definitely seeing more of this in these recessionary times, with medical practices particularly trying to find out common freeware type applications that they can use. Here the practice used a cloud-based email software for appointments for smear tests. That system was hacked. Patients received phishing emails which claimed to be from their doctors. Only 175 patients' email addresses were compromised, and thankfully no sensitive data was included in the compromise. The ICO settled the case on undertakings from the medical practice in April 2013. Let's look at the next slide. I think that we're also seeing security issues in other areas. It's a commonplace, I think, that there's less job security than there was before, and the medical sector has not been immune from that. There's also the ability for people to do more damage because stock prices are more volatile in these recessionary times. There are lower trading volumes, and there's a quicker spread of information because social media is the tools to enable people to do that. So if we look at the next slide, just an example of a company that I worked with, and obviously in my practice a lot of what I'm doing is working with pharmaceutical companies, medical companies, to look at how they engage with social media and how they address those risks. I looked at one company in 2010 as an example, a relatively small pharmaceutical company. Over 2,000 employees had signed up to LinkedIn. They had around about 6,000 followers. The average age of their employees on LinkedIn was 33 years of age, but their average tenure at that business just 3 years. So in the past, for example, my father and his father had one employer for life. They were loyal to that employer. They didn't tend to say things about them, in the precursor to social media, which I suspect was down the pub or down the club. But here, because employees move on much quicker, because there's less job security, they talk more about their employers when their employers get things wrong. So on the next slide, there'd be an example of the Varian case, for example. Here there were two aggrieved ex-employees. They sent 14,000 messages about how bad the company was to 100 different sites, and they caused a dip in share value of around about $750,000. So employees do try and take it out on their employers if they see bad practice and if they see people at the employer profiting through stock options or whatever. On the next slide, let's look at a slightly different topic, that of disclosure. And with Paul's consent, I'm going to use a US example here, but I think that the law would be the same across Europe. The FDA case against the Novartis to Singer Facebook widget here on the next slide. There was a routine FDA monitoring and surveillance program. There was a Facebook widget on the Novartis site which had a link to a website with the FDA required disclosures, but did not contain them themselves. The FDA said that the widget was misleading, and there'd been no prior submission to the FDA of the widget. The FDA said that it was misleading because there were no boxed warnings, contraindications, warnings and precautions, and adverse reactions. This is particularly important on social media. Facebook, yes, Twitter even more so, because you're limited to 140 characters. You can't talk about drugs and give information about what those drugs do in 140 characters. So pharmaceutical companies, hospitals, prescribing organisations are going to have to watch when they're mentioning products to make sure that the adverse effects and the possible consequences of those products are explained properly. There's a temptation at the moment, on the next slide, to bring into place P2P sites, conventionally called peer-to-peer sites in the industry. You could almost call them patient-to-patient sites in the medical context. And quite often what we're doing here is we're almost having like an online self-help group. So for example, people who've had a heart bypass could be encouraged, perhaps sponsored by a medical company, to talk and share their experiences and help each other. Very laudable in itself, but not without risks from a legal point of view. I'm not saying don't set up these sites, I'm not saying don't allow patients to help each other, but I'm saying that these sites will need to be controlled for a number of reasons. Firstly, moderation. Many of you will know that there's a real scandal across Europe in connection with a site called Ask FM at the moment that allows anonymous postings and has been a forum for bullying. So moderation will be important. Not a straightforward decision for most operators of these type of forums. Firstly, because of expense, obviously moderation costs money, and secondly because you may lose what's called the mere conduit defence. There is a defence in most parts of Europe against social media operators if they don't know of content, but if they moderate they may lose that defence. Next, the issue of promotion and plugging. We are seeing more and more of these cases, particularly with celebrities being given products and then saying they worked really well for them. We've seen cases around weight reduction, for example, already, and we're likely to see more and more of those cases, I think. So if you're encouraging people to join your forum, for example, or push your product, that needs to be regulated as well. We're seeing misleading product benefits. My favourite, we did a podcast on it, I'll give you the link at the end, was the regulatory action in the US against an iPhone application, and it said that if you downloaded this iPhone app and put it up to your face, it would reduce acne over time. Obviously a lot of these applications are entirely bogus, so be aware of the claims that you're making, particularly if you're hosting the site. Privacy issues as well. The Swedish Data Inspection issued guidelines on hosting these type of sites, saying that the hosts would be responsible under some circumstances. So again, there's a risk there. And there are a whole host of jurisdictional issues as well. Obviously some pharmaceuticals may be permitted in some countries but not in others, and some procedures may be more heavily regulated in other countries. Abortion, for example, would be one of the starkest examples. It's important, if we look at the next slide, that not only does an organisation plan for these risks, but it also rehearses what it's going to do if any of these risks manifest themselves. As you'll see on the screen, the Dutch data protection regulator has said that every organisation, as far as security breach is concerned, must have a plan, but must also rehearse it. And I think we're going to see the same requirement in other areas as well. Let's look at the next slide as to what the consequences of getting it wrong might be. Well, obviously there are all those medical consequences that Paul's described in his talk, but in addition, private rights of action from individuals, possibly class actions, although they're less common in Europe. The intervention of pharmaceutical regulations, like in the Novartis case that we described, the intervention of data protection regulators following the data inspection guidelines, that sort of thing. The intervention of fair trade regulators, like in the Facebook acne app. The intervention of advertising regulators, so for example for breach of the CAP code in the UK, but more importantly reputation. In health, reputation is all important, and any type of regulatory action could diminish reputation substantially. So let's just look finally at what will happen under the new EU rules on the next slide. First of all, the distinction between processor and controller goes. Suppliers outside the EU are going to be in scope. There's something called the right to be forgotten. Haven't got time to describe it, but by all means look in the materials, which will have a real impact on medical practices, and there are going to be more subject access requests. On the next slide, these laws will be uniform as a regulation, not a directive across Europe under the proposals. Fines will be 2% of global turnover. Toughened enforcement bodies. Consent is less of an option, particularly relevant to medical businesses, and breach reporting under the current proposals in 24 hours. On the next slide, there are also some new EU cybersecurity laws that are proposed, which will also affect what medical practices do. Then on the next slide, what are some practical tips? Well, education is very important. Policies are very important as well. Activities to protect assets, to make sure that the bad guys aren't lifting your intellectual property or masquerading as you. And reputation monitoring is part of that as well. On the next slide, when you see an incident, plan to act. Often the first incident is a very small incident to test you out, using your reputation, masquerading as you. It's to try and look at your responses. It's important that you assemble the right team, get them together and have them mobilised, ready to act. On the next slide, you'll see that there is a test I often do with my clients, the accidental outlaw test, which enables people to get that sixth sense about using social media, which can help you in a crisis and help avoid one in the first place. And that's a free test. It's a not-for-profit organisation that's put that together, and I was involved with that. On the next slide, there's some resources for you. Again, if you've not got the slides, you can download those from LinkedIn at www.bit.ly/linkjpa. So www.bit.ly/linkjpa. There's some hot links to some other resources on some of the topics that I've talked about, and I'm happy to take questions. My email address is jparmstrong@dwaynemorris.com. On Twitter, I'm ArmstrongJP. Again, sorry I couldn't be with you there in Copenhagen. Have an excellent rest of conference, and thank you for listening.